Mr. Lewison.
Sir, I stand in support of this bill. Lawyers I spoke to welcome in particular 3 changes that have been proposed. The first relates to the appointment of law experts in cases before the SICC, a move no doubt put in place to improve the quality of arguments raised in the SICC on foreign law issues. The second relates to the establishment of an unclaimed money fund to be administered by the Law Society of Singapore. The amendment will result in certain monies that are unclaimed being put to use in, amongst other things, pro bono services. Finally, there is the introduction of the imposition of remedial measures upon a regulated legal practitioner by the Council of the Law Society of Singapore or the Disciplinary Tribunal. Previously, the options were limited to the issuance of a warning, a reprimand, or the imposition of a fine. These were aimed at censuring and punishing the errant regulated legal practitioner and may not have addressed root causes for the impeached conduct. While the precise type of remedial measures that may be imposed will be set out in further subsidiary legislation, it is heartening to see that there is now another option available, which is not entirely punitive in nature. However, it is with this last change that I now seek clarifications. The bill proposes to allow an inquiry committee to recommend to the Council of the Law Society of Singapore that a penalty, warning, reprimand, and/or requirement of compliance with remedial measures be imposed on a practitioner without any formal investigations by a disciplinary tribunal. The Council of the Law Society can then make such a determination under the new Section 87 of the Act. Significantly, the amendment to Section 88(1) proposes to make the imposition of a penalty, warning, and/or reprimand mandatory by changing the wording to must give from the original may give. The question is, why are we changing from a may to a must? Lawyers I've spoken to are concerned about the mandatory imposition because this seems to render the practitioner's opportunity to be heard on the matter under Section 88(3) futile. In the interest of fairness and in line with the right to be heard, the practitioner really ought to be able to make his or her case on the matter, and Section 88(3) should remain. Can SMS clarify how Section 88(3) is consistent with the mandatory imposition under Section 88(1)? Further, I note that the imposition of the remedial measures by the Council is sought to be introduced by way of a new Section 88(1)(a). But Section 88(3) of the Act remains unchanged. This seems again to suggest that a practitioner will not be heard before remedial measures are imposed upon him or her by the Council. Can SMS clarify whether a practitioner also has a right to be heard before Council imposes remedial measures on him or her in the same spirit of fairness? So while we welcome the introduction of measures that focus on remediation rather than punishment, I hope SMS can clarify whether the right of the practitioner to be heard will be preserved. So notwithstanding the above clarifications, I stand in support of this bill.